Okay, good evening. Welcome to the May 17th special meeting of the Planning and Zoning Commission, Architectural Review Board, and Board of Zoning Appeals. It's a special meeting for board and commission training. I'm Nikki Martin. I'm a senior planner with the City of Dublin. We are joined as well by Tammy Noble, also a senior planner, and our consultant, Greg Dale, with McBride Dale Clarion. Greg will be facilitating our training this evening. So without further ado, I'll let him introduce himself, and then I'll facilitate some introductions as will Tammy of our board and commission members. Greg?
Great. Hello, everyone. I'm Greg Dale. I'm a principal with the planning and zoning consulting firm of McBride Dale Clarion. And I'll tell you a little bit more about my background as it relates to the training that we'll be doing here. It's really more about a discussion that we'll be having here as we get to it.
Great. Thank you, Greg. So we will go ahead and start with the Planning and Zoning Commission for introductions. Rebecca, would you like to introduce yourself, name the commission you serve with, the number of years of service, and then why you chose to serve? And then if you could facilitate the introduction of the rest of your commission members, that would be great.
Certainly. Thank you, Nikki. So as Nikki said, my name is Rebecca. Last name is Call. I've been on Planning and Zoning Commission for a little over 2 years now. I've served as Planning and Zoning Chair this last year and a little bit. I chose to serve on the board because I think that Dublin is an amazing place to live, and it's always wonderful to be able to volunteer service to something that is lasting. So there's nothing more lasting than a community, and to be part of that community is why I chose to serve. So at this time, Kim, if I could turn it over to you for introduction.
Good. That was me, right? Rebecca, you're a little muted, so I couldn't quite hear that. So I'm Kim Way.
Yeah.
I'm on the planning and zoning, obviously. I'm the newbie on the board. I've been on for 2 months. So I've had 2 real working sessions. We have our 3rd this week. And I'm Greg Dale well, so I'm really looking forward to hearing more what Greg has to say because we spent some time together. Thank you.
Warren? Warren, you're muted.
I'm Warren Fishman. I'm probably the least computer literate on the board. I've been on planning and zoning for about 40 years, with 8 on, 8 off, 8 on, 1 off, 8 on, 1 off, so on, for the last 40 years. I've really enjoyed seeing the city grow in the quality way that it has grown over these last 40 years, and I've enjoyed working with the incredible staff over the years that we have in Dublin, and the incredible volunteers, and Dublin to keep getting better and better.
Thank you. Back to you.
Great, thank you. With that, I'll turn it over to Gary Alexander, the chair of the Architectural Review Board.
Hi, I'm Gary Alexander. I'm the senior member in a number of ways of our board. I've been on the board for 3.5 years. I'm an architect. I do a lot of work in historic districts and before architectural review boards and public bodies quite a bit. And I felt like I could offer some expertise to the community. Amy, would you like to go next?
Sure, my name's Amy Cram. I'm serving as the vice chair in the Architectural Review Board. I've sat on the board for about a year now. I'm an architectural historian, and a historian. I'm actually serving on the board on behalf of the Dublin Historical Society, where I serve as the vice president. And years ago, I served on the Planning and Zoning Commission with Warren for 7 years.
Sean?
Sure. Good afternoon or good evening. I'm Sean Cotter. This is my 2nd year on ARB, And by background, I'm a mechanical engineer. And certainly the reason that I wanted to serve is I think Dublin is a great place to live. And I think the interaction between boards, commissions, city council, and the community is the way that you strengthen. The ideas come from a lot of different areas. And I think having boards and commissions close to the community is a way to make sure that Dublin remain, or communities in general and Dublin specifically, remain strong. Thanks.
Frank?
Hi there, Frank Konecki, ARB as well. And like Sean, I came on about 2 years ago. Bringing to this, besides history degrees, preservation degrees, also working with old buildings for almost 20 years now from both the city side and also from a contractor side. So just hoping to bring some of that knowledge to bear as I sit on this board.
That's all of us, Nikki.
Wonderful. With that, I'll turn it over to Tammy.
Hi, everyone. I'm Tammy Noble. I'm also a senior planner with the City of Dublin, and I've been fortunate enough to work for the Board of Zoning Appeals. I've interacted with all the boards in some way, shape, or form, but we have a great team, and I'm trying to look for Jason. Jason is the chair. There you are. The chair of the Board of Zoning Appeals, and I'll let him introduce his colleagues.
Hi, Jason Deschler. Like Tammy said, I'm the chair of the Board of Zoning Appeals. I'm going on to my 4th year. And let's see. For me, I grew up in Dublin, and to give back to the community in really any way possible, I felt with my background being an attorney, this would be a great opportunity to serve on the Board of Zoning Appeals. So having a great time doing it, I'm very fortunate to serve as chair. And I'll run down. I don't know if everybody's going to be on, but I see Joe. Joe, do you want to go next?
Sure. Joe and I'm the vice chair. I think gosh, last year's hard to keep track of. I think I'm starting my 3rd year on the board. Kind of like Jason, same thing. I'm an attorney, wanted to give back to the community. And I think we kind of took similar paths doing so, and wanted to, just participate in the city in a different way than I would have otherwise, and really enjoy the people that I work with that are on the board, and have learned a lot in the time that I've been on so far.
Let's see. I don't know. Alicia, are you on? Can you hear us?
Sure, I'm on. Hi, everyone. Alicia Miller. I am not an attorney, but I moved to Dublin about 3 years ago. We built here, and we picked Dublin because it's such a pretty place to live. The people are so nice. There's so much vibrancy. The town has done such a great job of bringing in employers and restaurants and interesting things to do and lots of park space. And so when we moved here, I just thought it would be a good idea to try to give back. And this seemed like a good way to do it. So I love working with the team. I've only been doing it for, I don't know, we started right before the pandemic, really, so about a year. I've never actually met my team in person, but that's okay. They're great to work with either way.
Thanks. Let's see. I don't know if Sarah's on, but I see Robin's on.
Yeah, Sarah's not on.
Okay.
Hi, everybody. I might be the most junior person on this call in terms of time served. I've only been to one meeting at this point. I enjoy city planning, so I decided to do something related to city planning, and this seemed like a cool way of being involved from that aspect.
Okay, I think we're good. It's our 5, with Sarah not being here, so.
Great. Well, thank you all for those introductions and your service to the city. We'll flip it back to Greg to facilitate the training.
Great. Thank you, Nikki. Is that Jesse? Are you on this line? Are you on the caller? Is that?
Jesse should be with us.
All right. So the attorney for the city, Jesse, is one of the attorneys. Nikki, do you want to introduce him real quickly? Because
yeah, sure. Sorry, I completely neglected to introduce him. So we have Jesse Shamp with us. Jesse works closely with Thad Boggs, who is also assigned to both planning and zoning matters. So we're lucky to have him with us this evening. And should you have any questions regarding, how we would approach something from a legal standpoint, we can certainly get his input on that.
And I think he's in the car, which is where he may or may not have a good connection. So anyway, okay, well, let's get started. So we have about an hour and 5 or 10 minutes here to cover this material. So just so you know, before this call, we had another session that focused just on the chairs and the vice chairs of the boards and some of their particular unique responsibilities. But in the course of that discussion, we had a lot of other things come up that'll probably play into what we're talking about today. So you may hear some of that being discussed. So you should have a handout in front of you. I'm not gonna pull that up on the screen because I want us to be able to see each other. So you might pull that out and have that in front of you, or pull that up on your screen. And what I'd like to do is just kind of walk you through some issues that I've seen come up with boards and commissions over the years. Some of these are going to be self-evident, but I will tell you that everything I have on here because I've seen boards and commissions who don't necessarily do this well. So some of this you might say, really? People didn't open their packet before they came in the meeting, but yes, that happens sometimes. So let me just put these out there. Feel free, please do interrupt with questions or comments or different perspectives if you want. Just jump in or wave your hand, however you want to do that. I can just present this all straight through, but I think it'd be much more engaging if you all can give me your thoughts as we go. So let me start with kind of a broad topic here that I think is important. In that I've worked with a lot of boards and commissions who basically get frustrated because we can't make their job easier, right? So what we're going to be talking about are some ideas to help you improve your job, perhaps make you more effective as boards and commissions. But one of the things to realize is your job is always going to be hard, right? We're dealing with planning and zoning issues, and if people were asking for zoning approval for something that was entirely non-discretionary, in other words, you pull out the book, you measure things, you look at use tables, you do the calculations, if that's what this was all about, then staff would do that, right? We don't need you to do that. We need you to make the tough calls. So by definition, your job is going to be to make what we would call discretionary decisions, not unreasonable decisions, not ambiguous decisions, not arbitrary decisions, but they are discretionary decisions. So you are by definition being called to make the tough call. So your job will never be easy. What we hope we can do is make your job a little easier, and perhaps even more importantly is have you do your job in such a way that people walk out of your hearings, your meetings, feeling like they were treated fairly and with respect, even if they didn't get the result that they were looking at. I just think that's an important thing to understand as you start with. You are by definition making the tough calls. Okay. Another self-evident thing, but it's worth repeating, be prepared. Right? When we're talking about decisions, requests that come before you, you should understand that when you're acting in that capacity, you are part of the government, right? You are making legally important decisions. You probably have all served in lots of volunteer capacities, lots of community capacities. But when you're sitting up at that dais or at that table or behind the Zoom call, whatever it is, in a meeting where people are asking for your approval or people are arguing that you shouldn't approve something, you are acting in a legally prescribed government role. And you are representing the city of Dublin in doing so. And so the face that you put forward as a board is representative of the city. And I just think it's important that you understand that that is very serious business. And by agreeing to serve in that board, I think you are agreeing to do certain things. And one of those is to be prepared. I emphasized to the board, to the chairs earlier, that they need to understand your code and your plans and your community, but so do you. And at some point, I know this sounds daunting, but at some point, you need to become familiar with your full zoning code, or planning and zoning commission if you're dealing with subdivision regulations, those. your planning programs, and Dublin has lots of special area plans and a comprehensive plan. You all need to be experts on those, citizen experts, not professional experts, but you should know those. I made the point earlier that when you look at a zoning code, very rarely, if ever, can you just go to a particular place in the zoning code and have that all you need to look at as part of a particular case. Zoning codes are notorious for having, you know, arms that go all throughout, the definitions, the use table, the development standards. You know, you really need to understand all of how that works. And yes, open your packet before you go into the meeting. I've literally seen, that is a terrible sound to hear, the ripping of the envelope when somebody gets to the meeting and they're opening their packet. I'm sure none of you do that, but I have seen it happen. I think it's important to view sites, and there may be some discussion on that depending on the board, but part of being prepared, in my mind, in my opinion, is to view the site and surrounding neighborhoods. Now, a couple things about that. Don't go on to property unless you have advance permission to do that. And Nikki, maybe if you want to talk about that process separately, we can do that. But generally speaking, go drive by the site, view the surrounding area. Don't talk to people out there. We'll talk about ex parte contacts here in just a minute. But I've been in this business for a long time, and I've every time I've looked at a site in a staff report or Google Earth, Google Street View, whatever it is, I have a certain perception of it. And when I go out and I drive the site and look at it, every single time I think that's a little bit different than what I was thinking when I was looking at it. So there's no substitute for doing that. Now, if we want to talk about group trips to view sites, we can do that, but that's a kind of different topic. Nikki, is there anything else you want to talk about with site visits?
No, I think we can wait to see if there are any questions regarding site visits. I would say it is often helpful to view the site. If you are viewing the site, you should always be viewing that site from the public right of way, and not be accessing private property without authorization of the property owner.
Right.
You should also be visiting that site independently from one another.
Yeah.
And you know, should you be approached by somebody at the site, clarifying what your role is, particularly if, you know, that person potentially has public comment about the site, directing them to make that, you know, through staff, and, you know, that you would not be the correct conduit for that. Those are just my quick rules of thumb.
Yeah, and if the issue of ex parte contacts, that is talking to people outside the meeting, we'll come back and deal with that separately here in just a minute. And if there is that rare instance, I don't know, maybe it's a backyard fence variance or something where you're thinking, I really do need to see something on the site, that's going to be an exception. And when you do that, contact staff, and they will help you figure that out. They'll work with legal counsel to do that in the appropriate way. So I don't want to make too much out of that, but I just want to be clear on what that is. Okay. So, and I'm going to watch for waving hands if you have any questions. So feel free to do that. So be respectful. Again, I know this is kind of self-evident. I hope it's not too simplistic for you, but here's the thing. I have been before so many boards and commissions where some of it is just as a result of fatigue as time goes on. Some of it is just, you know, just not realizing what kind of signals you're sending. But I think body language, I think the way you comport yourself in a hearing is really important. And one of the things to understand is that when people are appearing before you and they're sitting at that table, talking, speaking, testifying, whether they're an applicant or a neighbor, whatever, this is a really big deal to them. In many cases, it's the only time they've ever done this. Even if it's an applicant that has done this many times, it's really important to that applicant. So no matter how many people you've heard that evening, keeping your body language such that you're paying attention to them, you're not on your phone, and I'm sure you don't do that, but I have seen situations where somebody's on their computer. Maybe they're looking at the site, but maybe they're not. But whenever you start seeing, you know, eyes go to screens, people feel like you're checking out on them. So making eye contact, active listening, just the way you comport yourself is really important. And I know that sounds self-evident, but remind yourself of that when you're 2 hours into the meeting and you find yourself starting to do this, right? Is just to remember that everybody that sits in front of you, everybody that's talking to you, wants to feel like at that particular point you are focusing on what they're saying and what they're saying alone, and they have a right to expect that, right? So then, again, just that whole professional decorum, managing the emotions of the crowd. One of the things that I'm going to emphasize as we go forward with this is the importance of a laser-like focus from you on this simple equation. Our job is to listen for facts that allow us to determine if our standards are being met, right? So that means that how emotional somebody is, how worked up the crowd is, how many people are there, how many people sign a petition, all those sorts of things, that really has no bearing in your world. It might when it gets to city council. I don't know, that's not my job, but in your world is really simple in concept, facts and standards. That's what really matters. So if you can keep people, yourself included, in the room, if you can keep the room focused on that and try to keep emotions out of this, that's really important. The be professional, I say, take off the friend hat. You will have people that appear before you that you know. There's no doubt about that. And we'll talk about conflicts here in just a second, which is a little bit different issue. Oh, it looks like Alicia's having connection problems. But I say take off the friend hat. Don't go out before the meeting and glad hand all the people that are there. Don't be slapping people on the backs. Don't be using first names with people even before the meeting. Keep that professional decorum. Try not to use first names, right? Try to use Mr., Ms., whatever it is. Just those kinds of professional decorum kinds of things. Kind of think a little bit about, it's almost like if you picture how a courtroom would operate. We don't expect you to be judges and we don't expect it to be like that, but it's kind of like that same kind of decorum. This is a government function. This is a legally established process that you're involved in. And while you want to have a friendly process, and we'll talk about that in just a second, you can have a user-friendly process that operates in a very professional decorum kind of way, if that makes sense. Okay. Focus on facts and standards. That's kind of what I was just saying earlier. Find the facts and apply them to the standards. So when you have people that speak before you, whether they're an applicant or an opponent, you have every right to expect that they are going to be presenting you with some version of facts. And if they don't, if you have somebody who just has an opinion that I think this is a really good idea, or I think this is a really bad proposal and you should deny it, you have every right as a board to ask them to explain themselves. You can't make them, but part of the user-friendly process is to say, well, sir, that's helpful, but could you explain why you have that opinion? Can you tell me something about that proposal? Can you be specific? You have the ability to draw people out, because ultimately opinions that aren't based upon some basis really they're not helpful to you. If somebody just comes in and says, I think that's a bad idea and that's all I'm going to say about it, thank them for coming. And then when you go to deliberating and making a decision, that really shouldn't have any bearing on your decision, just if somebody doesn't like something. But you can also help them out because they don't know the process. You can help them out and say, can you please explain why you think that? Can you provide us with some information that we can use? So I think that's really important. And the idea that you represent the community, not your personal views. I said this to the chairs earlier. Your job is not to apply your personal opinion about something and decide whether or not you like what's being proposed. That's not your role. Your role is to be a part of a process that's listening to facts and information and applying those facts to standards. I'm going to beat that to death because it's all about facts and applying them to your standards or guidelines or policies or whatever you want to call it. So that, before we flip the page here, do we have any comments or questions about any of that? Or Nikki or Tammy, is there anything you guys want to add?
I don't have anything to add.
Okay.
Thank you.
Okay. All right. So then let's talk about meetings. And we talked about this with the chairs also. And in a minute, I'll share some of the other kind of conversations came up with the chairs that we can share with you. But you know, running fair and efficient meetings. And those are things like making sure you have clear procedures. I talked about the importance earlier with the chairs about having a point at the beginning of the meeting where you are explaining the process. People come in and they have anxiety over these meetings. They don't like to speak in public. They don't know how this works. They feel out of place. And the more you can do to explain to them how this is going to be run, what's the order of the meeting, what's the expectation, are they going to be asked to live within a time limit when they speak, which you have every right to do. But to, you know, make it clear to people what they can expect in this. Managing the time, managing the speaking, focus speakers on facts. I've pretty much said that already. So here's another thing that's really important, and that is the idea of having an unbiased and open mind. Now that's tough because I like to compare you sometimes to juries in a trial, right? And I think we would probably all agree, just intuitively, everything we know about the court system in our country, that the expectation is that we want jurors to have open minds, unbiased, right? You know, the whole process of going through jury questioning, and if they have some bias that comes out, they're going to be kicked off because the whole thing is about having unbiased decision makers. Well, in principle, that applies to you too, but the difference is you weren't asked to be on this board because you were the only people who didn't know anything about any of this, right? You were asked to be on this board because you do have background, you do have knowledge, you do have experience. But at the same time, while we want you to bring that experience to the table and apply that experience, we also expect you to have an open mind about this. So two things that I would say about this, and I'm going to take the order on my handout. I'm going to reverse that here. Allow yourself to change your mind, right? If you read a staff report and you've already made up your mind when you walk in the door, you know how you're going to vote, then you're not being fair to the people that appear. There's nothing wrong with reading that staff report and thinking, okay, I have an understanding now, but I'm still going to hear from the applicant. I'm still going to hear from neighbors. I'm going to hear from people who are opposed. I'm going to hear from people that are in support. And I need to have the mental discipline to be able to say, you know what? I should allow for the possibility that I'm going to change my mind. I'm going to be influenced. I'm going to allow myself to listen to people and perhaps be influenced. And there's nothing wrong. It's not a sign of weakness to say, well, I came into this meeting with one thought process, and now that I hear what I'm hearing, I have a different perspective on it. And there's nothing wrong with that. And I think that's actually a really helpful kind of, I don't know, mental trick, you know, to use for yourself, that, okay, I have certain perceptions. I've looked at the site. I've read the staff report. I certainly have certain impressions of it, but I'm going to go in with the idea that, okay, I have an open mind. So convince me, applicant, convince me, opponents, convince me, give me facts that allow me to determine if their standards are met, and allow yourself the ability to change, to let your thought process change during the course of this. I think that's a really good just kind of checklist, mental checklist to have, because if you go in already knowing how you're going to vote, you may as well tell the people, don't even talk. I'm done. I'm finished, right? Let's vote. And that's obviously not fair to applicants or anyone else who's interested in it. Okay, so the other thing that clouds an open mind or an unbiased mind is conflicts of interest. So let's talk about those. And Jesse, I don't know if Jesse might have disappeared. If you can still hear us, Jesse, feel free to jump in on this.
I think Jesse dropped off.
Okay. So conflicts of interest. Let's talk about conflicts of interest, because to me, there's a couple of aspects of that that are really important. But again, the first idea, the reason why we're worried about conflicts of interest is that issue of an unbiased decision maker. I have a right to an unbiased decision maker, and a conflict of interest is what is going to potentially poison that right in the process. So a couple of things about that. One is, you know, legally established conflicts of interest. And there, you know, that's why I was hoping Jesse could jump in on this. If you believe you have a true conflict of interest from a legal perspective, and usually that's defined as a monetary stake in the outcome of a decision by you or a immediate family member. That's generally the idea. And I think my experience is most people have a pretty good radar for what is a true conflict of interest. But if you think you have a true conflict of interest, I hope it's obvious to you that you should not be involved in a decision-making process. You may want to talk to staff and get legal advice on whether you have a conflict of interest or not. But my experience is I've rarely seen that be an issue. What is more of an issue to me is in the realm of perceptions of conflict of interest or perceptions of bias. So I've over the years liked to use lots of examples. If my spouse is the applicant, do I have a conflict of interest? Duh, right? Yes, of course you do. What if my brother is the applicant and I have no financial ties to my brother? I have no monetary stake in the outcome of it. Do I have a conflict of interest? I don't know. Maybe a lawyer says I don't, but, and I see your head nodding, Amy, does the average person perceive that to be a conflict? Of course they do. Of course they do. And we could go on and on. What if it's your next door neighbor? What if it's 5 doors down on the same street? What if it's a business partner? What if it's a co-employee of the same company? What if you go to church together? What if you're on the board of deacons together? We can do this forever. And at some point, you're going to agree that there's gray area that's involved with this, where an attorney might say, no, you don't have a conflict of interest from a legal perspective, but there is that gray zone within which you have this range of, but yes, of course, the average person would perceive this to be a conflict, to basically saying, no, if you declared a conflict every time somebody appeared before you that you've met in a small town, you probably wouldn't get to vote on many things, right? So there's somewhere in there is a line. And here's the question, how do you draw that line? So the way I suggest you draw that line is to, first of all, take the idea that when in doubt, disclose it. If you have any doubt in your mind about it, disclose it to the board, put it on the record, put it on the board, determine what you think the true answer is. So here's the 3 questions I would ask. Is it a legal conflict of interest? No. Okay. Would the average reasonable person perceive it to be a conflict of interest? And if the answer to that is no, then the third thing is, in my heart of hearts, can I say that I can make a fair and impartial decision on this? You might have, I'm trying to think of an example where a lawyer would say, no, you don't have a conflict. And the average person would say, no, you don't appear, there's no perception, but you might say, you know what, though, I had a run-in with that guy a couple of years ago and I just don't like him, right? I just can't get past that. And I've got a real problem with this. And I've got I just don't think I can be impartial there. So, in my mind, err on the side of disclosing. Yes. Yeah, go ahead, Robin.
Yeah. Is the first time you said you would disclose it, is the first time you disclose it if you think you're on that line during the meeting, or do you disclose it to a staff member before the meeting, or when does that happen?
Good question. So typically what I would encourage you to do is, first of all, I think keeping the lines of communication open with staff, because staff's been through this before. So if you were to call Nikki or Tammy or Jenny or whoever and say, look, I've got this situation, can you help me think through it? But then to answer your question, I think the way I've seen it done, the way I've always understood it, is when you get to the meeting, when the case is called, before anything else starts, you declare that at that time. And here's what I've seen done very effectively, and this is a judgment call. Maybe you won't agree with me here. I would like for the board to know that I have this guy is another father on a baseball team that I coach, a youth baseball team that I coach. And I don't think I have a conflict here, but I wanted to disclose that because I have a relationship with this guy. And so, and here's the part that I want to see if you agree with this. And so I would ask for the permission of the board to continue to participate in this. Now, do you have to have their permission? No, ultimately it's your decision. But I've just always thought when somebody says that, what they're really saying is, look, if you don't think I should be involved in this, I don't want to be involved in this, right? So if my board members perceive that there's something unseemly looking about this, even if I've made all the conclusions that I don't have a conflict and I don't think it's a problem, if I find out my board members don't want me to be involved in this, then I really don't want to be involved in it. And frankly, if you find yourself saying, well, I'm going to do it anyway, then you might be making the point that you have a conflict. You have an issue that's biasing to you. If you want to stay involved so badly that you're willing to go against the sentiment of the board, that alone should be some indication to me. But that's a judgment call. Ultimately, it is your call. Ultimately, it is your decision to make in terms of whether you're going to recuse yourself. And then the question would be, what do you do once you've made that conclusion? And I think it's pretty simple. This is before the case is heard. If you're going to be recusing yourself, get up and leave the room. Just be out of the process. Don't sit there and watch it. Don't sit there silently. Don't go sit in the audience because that just raises questions. Who are you going to sit next to, right? Just get up and leave the room. Go sit in the lobby. Go sit in one of staff's offices or something while this is going on. Okay, that makes sense? Anybody have any problem with that or disagreement? Tammy?
I just have a question. So I remember one of my first meetings where someone asked to recuse themselves. They actually participated. They didn't disclose it to staff, participated in the discussion, and then when the vote came, they disclosed that they weren't going to be voting, and I had no clue what to do. I'm like, well, this is awkward.
Right.
Do you have any advice?
Well, yeah, don't do that. No, seriously, I think that's why we have these kinds of discussions is I think having an understanding among you now and not when it happens to come up and you're surprising everybody at the last minute to have agreement, consensus that that's what you want to do. And Tammy, the fact that that happened and you thought it was awkward makes the point. It's like, wait a minute, this doesn't feel right. Right now, and you're thinking, okay, did they ask a question? Was that a question designed to influence the outcome? You know, I think you just err on the side of caution there. Now, again, I don't know that your attorney, you have to be careful sometimes when you ask attorneys questions because what they're telling you is that is not illegal to do, but that doesn't mean it's the right thing to do in terms of public perception and good government. Rebecca, did you have a comment?
Yes, I researched this particular item when I first moved to Ohio because I served in boards in a different state. And if I recall correctly, Ohio was super strict, and I'm not going to get the exact right, but it is, you are supposed to remove yourself from the room and not participate in any of the discussion. They're kind of the extreme. And so, I would tend to err on the very, very, very cautious side. When there is no true conflict, it's always, to your point earlier, where there's a perceived conflict, it's always best to disclose it. But where you cannot participate, you should not participate to any level on that item.
Right. And I'm glad you said that, Rebecca, because the other point I would make is a little bit beyond the scope of this discussion, but there are state laws that apply also. There are state ethics, there's an Ohio Ethics Commission. There's a whole realm of things outside of the Dublin world of your zoning code and your charter and your regulations. And that's all the more reason why you would want to get legal advice. You really don't want to be making the decision on your own as to whether something is legally a conflict of interest or not, because it's well, you just don't. I think that's self-evident why. But okay, is everybody good with that? Err on the side of caution. Okay, so the next one is talking about conducting the business of the public in public. And again, I hope that is a self-evident idea, but here's the issue that comes up with that, and that is ex parte contacts. So I think you probably all understand there are public records and public meeting requirements and sunshine requirements and all that apply to guarantee or to ensure the idea that we're making public decisions in public. Where I think you run into a problem with that is with this concept of ex parte contacts, which is basically having contact communications with people outside of the hearing or the meeting process. And that's the telephone call you get from a neighbor or an email you get from an applicant, or running into somebody at the store, or the applicant wanting to take you to visit other sites that have a, similar development, whatever that is. And I think there's a couple of issues there. Again, it's sort of like conflicts of interest, and that is that there are some legal aspects of it, and then there are some essentially good government aspects of it. I think I've heard a lot of lawyers opine about this before. Typically, when for the Board of Zoning Appeals, I'm pretty sure lawyers would say for Board of Zoning Appeals, not only is it a bad idea, you may be endangering the process because you're acting in what's known as a quasi-judicial capacity, which is a discussion that would take us in a different direction. But basically, Boards of Zoning Appeals are particularly driven by procedural rules that are closer to court settings than what the Planning and Zoning Commission typically does when they're advising City Council. And the short version is Board of Zoning Appeals decisions are appealable directly to Common Pleas Court, and that puts a different set of rules on them. And ex parte contacts may, in fact, careful, not an attorney, may in fact create legal jeopardy for you. I have also heard attorneys say that Planning and Zoning Commissions, when you're acting in the advisory capacity to where you're advising City Council, that they're not necessarily illegal. I would argue they're still a bad idea. I think this is one of those where I apply the reasonable person standard. A reasonable person comes into your hearing and they find out that you've been having private meetings with the applicant. How are they going to feel about that? Are they going to feel like that's fair, or are they going to feel like something smells a little fishy here, right? I think they do. And I can tell you, I've done this all over the country, and what I'm saying to you is pretty much the universal sense. Every once in a while, someone will argue that they should be able to do it, and I'm not going to argue the law because I can't, but I can just tell you that across the board, typically speaking, reasonable people that are involved in this, they think that it smells fishy when you're out having private meetings. Just imagine an applicant coming in and speaking to you, and then all of a sudden he or she realizes you've been out at community meetings, you've been out doing the neighborhood circuit, and you've been out talking to the neighbors. They're going to feel like they're toast at that point, and the other way around. So I just think that the ex parte contact thing is not worth the effort. I get the idea that you might want to just do your homework and get as much information as you can. But again, I think that it's so much more fraught with downsides than it is worth any benefit you get from it, that I think the safest and easiest thing to do is simply say, if somebody tries to contact you, I'm sorry, I can't talk to you. Feel free to contact staff, and you can go online and see when the meeting is. We'd love to have you come to the meeting and tell us what you think, but I can't talk to you. And I think that is something that all of you should agree on, because if some of you are doing it and some of you don't, that's not good either. And frankly, if I were you, I would just be thinking my life would be so much easier if I don't do that, because I'm going to read the staff report, I'm going to read the code, I'm going to listen to the testimony, and that's going to be my decision. If you want to engage in that, that's city councils do that, and that's fine. City councils are elected officials. I think people have some expectation that they're going to be approachable outside the process, but I just think inside the planning and zoning and ARB and BZA, I just think it's so much simpler, I think, just to say we're just not going to do it. Does anybody have any heartburn over that? Okay. All right, so let's turn to this. So separate fact finding from deliberating, leave a trail, all those sorts of things. So here's going back to what I was saying earlier. Your job ultimately is to determine whether or not you're hearing facts that allow you to determine if standards are met. So a couple of things about that. One of them is this idea of separating fact finding from deliberating. I think it's good practice for all of your boards to have a basic procedure whereby there is a period of time in there where you are hearing facts. You are hearing the applicant, you are hearing supporters, you are hearing opponents, you're hearing other people who have comments. And all you're doing at that point is fact finding. You're not tipping your hand because you haven't made up your mind, right? Until that last person had their say, you haven't made up your mind, because that last person has a right to have an open mind as well. And if you follow that principle, then what we're really interested in doing is just getting facts. You can be very friendly about that. You can have processes in place where people get up and they're nervous and they speak and they don't really say anything, ask them friendly questions like, can you please explain more about why that is? But those at that point are all clarifying questions. Those are trying to get more facts out into the record, so to speak. And always thinking about, I'm looking at my standards. I'm looking at the code section that applies here. I have it in front of me. And so when I hear people speaking, I'm looking at that and I'm trying to get people to talk about that stuff that's in the code. And then at some point, whether it's the proverbial, are there any other comments, or we're going to close this part of the meeting, or whatever it is, where you have essentially announced, we have now finished with fact information, and we, the board, are shifting into a deliberative process. And in fact, that means all you people in the audience, you're done now. You listen to us because you've had your say. And hopefully you've conducted it where everybody felt they had their say. Everybody felt like they had their opportunity to have their day in court with you. But then there's a point where you're closing that portion of the meeting and you're saying, we are now moving into deliberation. And I think that's where you should be starting to build your findings of fact. That's where you're starting to say things, well, and you're, taking turns. Well, what I heard from Mr. Such and Such, I thought was really compelling because it went to this particular piece of our code, this particular standard. And you're talking that through and you're trying to get to a point where you are weighing all of that information. You are sifting through. And part of that is, you don't say it rudely, but there are certain things that you just, are essentially rejecting. You have the ability to weigh what you're hearing. You have the ability to assess the believability of what you heard. You have the ability to conclude that certain things are really important and certain things weren't necessarily important, and start to build that information. And I think breaking away from that essentially negotiated process where you're negotiating with the applicant and you find yourself saying, well, if you did this, could you do that, and sorts of things. That's where I think these processes tend to get off the rails sometimes. So make sure that you've heard everything you need to hear in that fact-finding piece and ask all the questions you want to ask. But then turn to basically, now it's our turn to wrestle with this, weigh with this, put it together, determine if we have the information we need. There may come times when you say, well, you know what, I'd like to have such and such come back up. Maybe I misunderstood, or maybe there's a little more information. Some of that limited, but I think generally the idea of having a good line between the fact finding and deliberating, because when you're deliberating, you are essentially trying to build a board consensus, at least a majority consensus, right? You're trying to get to a point where you think that there is a consensus on the board of a certain thing, and then that's leave a trail, make findings to support the decision. So at some point, what should happen is some board member is essentially saying, all right, I think I see where the board is. Let me make a motion that I think is representing a consensus of the board. You don't have to say it that way, but that's what you're trying to do. And let me make a motion with reasons, with a rationale stated, and let's get that out there, and then let's start massaging that, and let's start discussing that, and let's start putting that together. But the whole key to me on this is cite the standards and cite the facts. So that's the idea, I think, so that, and then, we talked earlier in the earlier call about the nature of your minutes and whether your minutes are achieving what you want them to do. But the idea that at the end of the day, you have something that you can point to that says, look, there is our decision, and in that decision, in the findings, in the motions, is a good depiction or a good communication of the rationale for our decision and why we made it. And specifically that we assessed whether or not we heard information, testimony, facts to determine if our standards are met. Now I make that sound awfully simple and clean, and I know it's a messy process to get there, and there's always this so-called sausage making part of this that you're going to go through. But I think those are some ideas to help you kind of get to that point. That's a lot I just threw at you. So questions about that or comments? Nikki or Tammy, you guys want to add anything? Because you're there every month.
Yeah, I mean, I'm a little partial to BZA, but I will say sometimes if we're answering your questions, sometimes we're just trying to build a record just like the applicant. So it may not seem like it's, I guess, garnering any type of assistance to the argument. We just may be clarifying our points of view. A few times I felt like that opens up a discussion again, and that's not our intent. It's just to keep a good record of what's going on.
Right. Yeah, go ahead, Robin.
Again, this is me being very junior to this. BZA, I've noticed a couple times people will state their opinions while they're chatting, like, oh, I'm in favor of this, and here are the reasons, and then they'll continue asking the question. It kind of comes up organically. Do you have an opinion as to at what point we should be doing that in the discussion? Or...
Yeah, no, that's a good question, and I'm gonna. I hesitate sometimes because I know I try to make this sound really simple. So what I'm really trying to give you are some principles. So no, arguably you should not be expressing an opinion during the course of the testimony process. Now, to say I'm in favor of this may be different than saying, I'm starting to see some things that suggest that this is going to meet our standards. You can do the same thing, but again, just think about the fact that you have people in the room who are intending to testify. And like I said, this is really important to them. And if I'm sitting back there thinking, okay, I'm going to come up here, I'm third, and somebody says, well, I'm in favor of this, but I'm thinking, well, crap, why should I even bother now, right? I mean, they've already made up their mind. So I think that's part of the respect that you're trying to show. And I think that's also part of the mental discipline of just saying until all the facts are in, we haven't made up our mind. Now, we're all people. Are you going to be influenced by things as you're going? Of course you are. But I do think this idea that you go in with the mindset that, you know what, I might still change my mind. I might hear something from somebody, and every once in a while, it'd be nice to be able to say, wow, that is not where I thought I was going to end up on this when I walked in this room tonight, because such and such made a really good case for or against it, whatever it is.
And part of it might have just been my ignorance. Part of it might have been that it pretty much is after the discussion finished, and I just didn't notice it. So
that, again, that's where I think to understand the difference between fact finding and deliberating. When you're deliberating, there's nothing wrong with essentially taking turns and saying, yeah, I think I'm in favor of this. Here's why. But then have your fellow board members say, well, you know what? Did you hear what that person said? What about that? And that's the sausage making part of it, is to feel each other out. And there's nothing wrong with saying, well, doing a little, not negotiating, that's not the right word, just doing a little round table in a controlled way, chair recognizing all the speakers, so that people can hear you and it's all audible. But to me, again, part of the key, I'm going to wear this out, is going back to the why is that my opinion? It's not because I like it, right? Just, again, remember, whether you like something has nothing to do with it or not. It's whether or not it meets the standards. As I was saying to the chairs earlier, you can like something a lot and feel like you have to deny it because it doesn't meet the standards. Or you can hate something, that's too strong. You can dislike something, but if they meet your standards, you should be approving it. And if you don't like that, then there's a course, and that is, maybe we should look at our standards, right? If we're approving stuff that we don't think advances the community interest, staff, city council, maybe we should go back and revisit what we're being asked to do. So just keep in mind, when you're agreeing to serve, essentially city council has adopted the codes and the plans, and they've said to you, your job is to apply those, right? Nothing wrong with saying, I don't like those. So city council, can we look at amending those? That happens all the time. But otherwise, your job is to apply what city council has adopted and said applies. Okay.
I just wanted to add something. When you were talking about fact finding and changing your position, I've actually had times where neighbors have come to testify and brought up excellent points that, had we heard them previous, that could have changed our viewpoint. So it's a circular argument that we all should And I've said as much of, that's an excellent point and goes to this criteria. And so,
Right. Yeah, good point, Tammy, because that's important to understand because, staff, they're professionals, right? And they've been doing this for a long time, but they're writing their report based upon the application and their read of it and their assessment. But staff, just like you in a sense, and that, once this opens up and you hear all these viewpoints, Tammy and Nikki, I'm sure you've all been in positions where it's like, yeah, I hadn't really thought about that one, or that's a good point. And that's fine. So I think what I will say about the findings of fact, one of the easiest way to make findings of fact, and let's be clear, some of these cases are easy, right? Some of these cases are not controversial, they're not contentious, and sometimes the easiest motion to make is move for approval based on the reasons set forth in the staff report. Nothing wrong with that. But if you find yourself in a position where you're thinking, well, staff said this, but I'm hearing some other things, then you need to work a little harder to make the factual findings that distinguish those. And there's nothing wrong with that. I mean, these guys, this staff, they've been around a long time. They don't take it personally. I mean, if you overturn everything they ever say, they're probably going to get a complex about it. But otherwise, they put their professional opinion into it, and then they put it in front of you, and then people start testifying, and they know that you're going to sometimes come to different conclusions, and nothing wrong with that. Okay. All right. Just a couple of other things here. Stay within the code. We kind of talked about this a little bit with the chairs previously, and that is, the idea that the way I've heard it described is with a lot of planning commissions, and I've seen this all over, is the idea that, okay, our code sets a standard there. Our job is to get it up here. And that's not necessarily the case. I get the idea that you want to have the best quality development that you can have, but you also need to stay within your code. So asking for things to be added to a development that really have nothing to do with the determination as to whether or not it meets your standards, and you're only asking for it because you think it would improve it, just because you think it would improvement, you really need to be careful of that. So you really need to stay within your code. If you are saying, you know what, I'd like to see this condition added to the approval because that would help make it compliant with our standards, that's one thing. But if all you're really doing is saying, you know what, I got an idea to make this a better development, regardless of what our code says, I just think it would be a better development. That's where I think you need to be careful. And that's staying within your code and not asking for things or requiring things or conditioning things that you can't point back to your code in terms of the source of that. I didn't say that well. Does that make sense to everybody? Okay. Okay. And then finally, is just what I listed here, kind of the principles of due process. So a couple of things. First of all, I've worked with enough attorneys in the legal system to know that this is basically the key elements of procedural due process. My sense, though, is I'm not an attorney. I'm not going to tell you how to comply with these legally. What I am going to say is I would hope that you would look at these and say, I don't care what the attorneys say, these are good ideas. These are good concepts of fairness. Yes, people should have notice of what's going on. Yes, they should have an opportunity to be heard. Yes, they should have access to all information that's available that we are making, that we're using to make our decision. Yes, they have a right to an unbiased decision, timely decisions and findings. I would hope that you would look at that and say, those are just common sense notions of fairness that we should be respecting. Just a couple things I would point out on those. Notice, Tammy and Nikki, I can't remember if we've had this discussion before about things that you do that go above and beyond the legal minimum requirements for notice, whether they're signs in the yard or, on the website or whatever they are. But I think the idea is to recognize that the legal requirements for notice, whether it's mailing things out to people within a certain distance or publishing in a newspaper, or whatever, those are the legal minimum requirements. Most communities exceed those, and I think it's kind of good practice to be as friendly as you can with notice. Tammy and Nikki, are you guys doing some of that?
Yeah, so
Go ahead, Nick.
Okay. Yeah, so as Greg mentioned, our zoning code stipulates based on application type what a minimum required notice zone is. It varies from 300 feet to 150 feet. If you think about it, in a lot of cases, 150 feet probably isn't adequate. So in those cases, sometimes we would do a full 300, other times we would do the 150 plus all of the adjacent HOAs, which would then distribute that information to their networks. We also partner with the community and public information group to publish everything via the city website. So not only is it listed on the city calendar, but we have full transparency of all the applications that have been submitted to the city online 24/7. And then finally, we do post development signs with the help of our graduate student interns on every property that is scheduled for a hearing.
And you don't have to be the expert on all those. I think it is a good idea for you to be sort of conversant with all the things that the city does, both to meet the legal requirements and to exceed it. Because I think one of the things we often hear in communities is people come in and say, well, they didn't know anything about it, which is kind of funny because they're there, they heard about it somehow, but they feel like you're keeping a secret from them. And I think being able to say, look, not only do we meet the minimum legal requirements, we exceed it. We do other things. I think one of the things that's important to understand is that I talked about how when you're sitting there in that boardroom or whatever it is, you are part of the government. And I think one of the things you need to understand is what the attitude about average citizens are about government in general, right? You think about your perceptions of government, whether it's state government or federal government or whatever, you might not think about yourself as being part of the government, but when you're in that position, you are. And it doesn't take, well, this is a cynical take on it, but I think it's true. You have two strikes against you in the eyes of a lot of people that are coming before you because you are part of a government system. And you know what the attitude about governments is in this country. And frankly, I think it's always been that way. It's clearly more, what's the word I'm looking for? More divided right now, more cynical about the whole process. But it's always been that way. It's like, oh, there they go again. It's a government at work, trying to pull something over on us. Shenanigans behind the scenes, good old boy network, right? I mean, you hear all those things, and it's not true usually in most communities, but it doesn't take much to give that impression. So anyway, that's kind of a tangent with that. So we talked about the opportunity to be heard, running meetings, full disclosure. Let me go back. I'm just think of something else here about the business of the public in public. Public records. So if you have any question about what constitutes public records, you might want to clarify that with your legal counsel. But having said that, I know from experience that if you go home after a public meeting and you send an email to somebody on your private account to a fellow commission members and you're talking about something that happened at that meeting, there's a good chance that's going to be considered public record. Text that you send each other, I don't know if you've had it there, but I know in our part of the country, we have a couple notorious political disputes that started over council members texting each other on their private accounts. And it came out as public records. And it was embarrassing. It was bad. So, it's the old rule that before you hit send on anything, would you want to read about it in the newspaper? That's really what it comes to. Would you want to have to answer a question about it in a deposition? I mean, that's a pretty severe way to look at it, but just be aware that those, unless your legal counsel tells you something else, when you're talking about city business in writing, whether it's on a city account or your own private account, I think it's considered public record. Social media, be careful about social media. Anything you post on Facebook or Twitter or anything like that in your capacity as a board member is probably going to be considered a public record. Again, I'm not a lawyer. I can't tell you that, but I've just seen so many cases over the years where people get embarrassed by things that they didn't think through before they hit send.
And Greg, if I could just pop in here for a second, and Nikki, I'm sure you agree with this, but we do provide city accounts for everyone, city email accounts for the reason that we want you to communicate via those email addresses. So your private information is not disrupted by any type of records request. We've actually had city council members and other officials on some of our boards and commissions had inquiries into their private information because they've used private devices. So we just always encourage you to use your Dublin accounts if possible.
But having said that, don't think that you can bypass that by having official conversations with your private accounts. You just don't want to be in a position where somebody is making that request and you're having to talk to the legal counsel. Well, is my private text public record? And they're probably going to say, well, did you talk about public business on it? That's like saying if I put something on my private stationery, in the old fashioned days of writing letters, that it makes it not public record versus it being on a city letterhead. I think Tammy's point is well taken. That is, you have channels of official communication, but just avoid the whole temptation to say, well, I think I can find a way around that. Right. That's just bad practice, and it's going to come back to haunt you, because don't forget, you might not produce it, but the guy who received it might end up producing it. Right? I mean, that's the way a lot of these came out, is the receiver, or it got forwarded to somebody and that person, made it public. So anyway, just a caution. Okay, well, what else did you to the chairs? Were there other things that we talked about earlier that we wanted to revisit here from our earlier discussion? Did we cover it all?
I think the only thing that I can think of is when we are coming to the end of that deliberation period, and we're making sure to tie up in a nice, neat little bow the feedback to the applicant for any things that need to change before the application comes back. Mm-hmm. We will try to repeat all of those items and ask if there's anything that there is other clarification needed on. However, we're not perfect. And so if we ever get something frankly wrong, or you can count to 4 or whatever your quorum number is, and you didn't get that number, you got less than that number, that level of clarification at that point in time would allow for an applicant to go to the meeting minutes to the very end of the deliberation item and see okay, what they said was, I need to look at this, I need to look at this, I need to look at this, and everything else looks like it was discussed, but okay.
Yeah, and that's a good point. That came up earlier in terms of whether or not your minutes, which, as I understand it, they're pretty almost transcript-like minutes, which is good on one hand, but it's difficult on the other, because sometimes the important stuff doesn't shine through. So maybe one of the, and I don't know who takes your minutes, but maybe that you could improve that end part that you're talking about, Rebecca, which is, this summing up at the end. And that's something that you can help with. Again, if I'm the minutes taker and somebody's saying, all right, I want some key points to be reflected in the minutes, then I'm thinking, all right, I'm going to do those 1, 2, 3, 4, 5. And I think maybe gradually over time, and it also comes back to, you get the minutes and then you approve the minutes. So if you get minutes and you look at it and you say, well, I just want to clarify a couple of key points, that's a way that gradually over time your minutes might get closer to giving you that concluding set of summary statements. Good. Yes, sir. Warren.
You're muted, Warren.
Darn it. I do that all the time.
They know I do it all the time. I'd like to digress a little bit to the code. You talked about approving things that are within code. I think we in Dublin have gotten in the habit of encouraging that they be code, but actually to exceed the code. In other words, we're not, many times not looking for development that just barely meets codes. And the way we seem to encourage that is that there's very few developments that come in that are exactly code. They usually ask for a variant in that code some way. maybe less space here, do something, maybe buildings closer, and so on, that don't meet code. Do you think that's wrong to encourage developers? You can't say you've got to exceed the code, or we're not going to approve the development, but encouraging code by, so to speak, giving and taking a little bit, encouraging, exceeding the code.
Yeah, I get the question.
Greg?
Yes.
Do you mind if I just talk about process a little bit
Sure.
before you dive into that? Because I think you're going to have some really good insight on this, but it may be helpful, just for some of our other boards and commissions. The Planning and Zoning Commission does a lot of work with planned unit development districts, which is the exercise of basically establishing a unique zoning code or set of development standards for a geography, whether that be a neighborhood or a shopping center. So I think in those cases, there is an opportunity to ask for things that are maybe not specifically stipulated in the City of Dublin zoning ordinances, but may be appropriate in this planned unit development due to the types of requests that are being made. And then there are the other types of applications where we say, maybe that's a Bridge Street District application where you have a very defined set of zoning standards. I think, Greg, maybe you would have something to weigh in on that.
Yeah, so I think that's a good way to frame it, Nikki. So in theory, you should not be saying you meet our code, but we want more because we're Dublin, right?
Right.
You shouldn't do that. But having said that, Warren, what you just said, and I think Nikki amplified it as well, in many cases, it's rarely that simple, right? Because there's rarely that a point where you can say, red line says code is met, but we're going to exceed that. So I think there's a lot of gray area there. But what I would urge you to do is to go back to the idea of what is our motivation for asking for that little bit more, for thinking about exceeding the code. Is it because I want it? Is it because I like that architectural style better? Or can we tie it back to some city policy to try to keep, as you're going out away from the code, the further you go out, try to keep a handhold in that code, which is what policy are we advancing? What guideline are we dealing with? Yes, I realize there's a lot of gray area and there's a lot of negotiable, debatable slack in that equation. But and this is one of those where I've said, hey, it sounds simple in concept, but it's tough in practice. There is kind of that good faith effort that you all have to make, which is, am I trying to get more just because I like it, because I think it's better, or can I ultimately justify it back to something in our code, something in our plan, something that is achievable there? But again, theoretically, this idea that our job is to make sure it meets code and then exceeds code is just not right. It's just not the case. But again, knowing that there's a lot of gray area there in how you go about doing that. That makes sense, Warren?
Kind of, yes.
I may not be telling you what you want to hear, though.
Well, I think that it, like I said, it's a very gray area, and also there's things that are kind of unwritten things. Like, for example, for years and years, the tradition was to have a 100-foot setback on Brand Road. Okay, there was never anything in writing about that. Okay, but when a developer came in, we all knew that there was a 100-foot set, that all the other developments had a 100-foot setback. Okay, so we would explain that to the developer, and we'd say, well, we'll give you this. For example, mounding. Instead of mounding, we need you to have the 100-foot setback. Or sometimes the developer says, gosh, I need an extra 10 feet because the road's going to turn a certain way, and can I do 90 feet? We say, okay, if you mound it, okay, then we'll give you the 90 feet. So
no, let me play with that for a minute, because I think that's a good example. So my reaction to that would be, all right, so the 100 feet is not written down, but is there something in your code that talks about compatibility with street frontage? Is there something that talks about the importance of preserving the integrity of that corridor? In which case you can say, yes, that 100 feet, while it's not necessarily written, has become practice to achieve that objective, not just because 100 feet is cool, but because there's an objective in the code that we can tie it back to. That would be a good example of that.
Yeah, I think that's usually the way we do it. Yeah.
Okay. Yeah.
I think.
Additionally, I think that there's always opportunity, and sometimes it goes unspoken, and I think that does all of us a disservice. There's always an opportunity when an application comes and it presents something that is either ambiguous or not covered in code for us to highlight, hey, this item, we're going to discuss it tonight and we're going to come to some type of agreement. But while we're at it, staff, can we look at bringing this back for a discussion item for code? We don't need to reinvent the wheel. Every time we see something, we don't need to reinvent the wheel. If something comes before Planning Commission that ought to live in the administrative world, if something goes to City Council and it ought to live in the Planning and Zoning Commission, if there's a different place for it to sit, to live, that is that better solution, then highlighting that, because sometimes we'll forget. Sometimes we write it down on a note and I say, hey, talk to Nikki about this. And then we end late. I don't talk to Nikki. I don't remind her. Nobody else remembers. And then 2 months later, we're spending an hour on the next application that is the same item that had we put it in code, we wouldn't have to discuss.
Right. Right. And there are, staffs making, I don't think you want to rush out and change the code every time some case, it seems to suggest it. But what staff does is they keep track of that stuff. And there are times when they'll process a package of code amendments that relate to a number of different things that came up. And, one of the things that you all should be thinking about, I think, is having some time within the context of your meetings outside of hearing development projects where you can talk about these things. There's, you can have agenda items that are discussion of landscaping standards and things that we've seen. I mean, there's one of the things, particularly Planning and Zoning Commission, if you're not just the Zoning Commission, right? You're the Planning and Zoning Commission. And so that suggests that there are times when you're talking about things other than just zoning applications that come before you. So I think that's another important thing to keep in mind. I agree, Rebecca, you have a leadership obligation as Planning and Zoning Commission, not just processing applications that come in the door, but raising these issues. That's part of your job. Warren.
Yeah, I'm sorry. Okay. I think you raised an excellent point about compatibility. And so compatibility is usually a good argument for exceeding the code. It might meet code, but if the development just meets the code and doesn't do this or that or a setback or whatever, it not only sets a dangerous precedent for the next development, but it also makes the other development look bad. I mean, we're trying to get the best for Dublin, total Dublin, not just one development. Yeah, Tam, I think that's it.
Nikki.
Yeah. So Warren, I think you make some excellent points, and your history is with the city is certainly evident. I think a lot of what you're talking about is planning, and Greg, you'd kind of picked that out as well. A lot of these elements, like the Brand Road setback, those are elements that are identified in the community plan. And so it's not as black and white as a code requirement, but allows that flexibility that, if 100 feet aren't able to be accommodated in this one area, but 90 feet with mounding is able to be accommodated, those are the types of discussions, particularly when you're establishing a planned unit development district. That's when those types of things are appropriate. And really to tie it all back to criteria, because that's where we want to be at the end of the day. Many of our criteria for all of our boards and commissions, with the exception of the Board of Zoning Appeals, cite the City of Dublin Community Plan, and whether or not that document is met, as well as other policy documents adopted by City Council. So if you ever determine as a board or commission member that an element of the community plan that's applicable to a certain site is not met, that is really the criteria that you would want to rely on to have foundation or standing for that conversation.
Yeah, and I think to wrap up my sense of what you're saying, Warren, because I think I'm almost right there with you. I think the way I would say it is when you're dealing with a given application, there's probably more than one way to meet the code, right? There's a good way and a bad way. We want to find a good way to meet the code, and I think the key is to do the hard work to tie it back to a planning policy that you're trying to achieve, and don't slip out into that. I just think it would be a good idea to do it this way. Try to ground it back in some city policy or some plan and something in the comprehensive plan.
I was going to mention that because the neat thing about the community plan, it's not like a code, it's fluid. And so therefore it gives you flexibility and helps people exceed the code and make a better development.
Right. So I think that's a good point to finish on. If that's okay with everybody, we're a few minutes past our quitting time. Are there any other final thoughts? All right.
Okay.
Nikki?
Well, Greg, we want to thank you for your time this evening. This was fabulous. Greg we're very lucky to have him. He does what he does exceptionally well. And, you know, if you've not had an opportunity to meet him before, I hope this was a very pleasant introduction and you can meet him again. So with that, we will adjourn for the evening. And I will stop the live stream. So I hope you all have a lovely night.
Thank you all.
Thanks, Nikki.
Thanks.
Thank you.
Greg.